Thank you everybody for registering for this webinar. Really appreciate it. Let me go ahead and introduce our speakers. Myself, I'm Jonathan Marashley, and I'm the managing partner at Marashley and Donahue, the CommLaw Group. Also the founder of the Compliance Group, which is its affiliated consultancy that focuses primarily on regulatory compliance management outsourcing. And I'm partnering today with Ryan Guthrie. Ryan is with Advanced Technologies and Services, ATS. I have worked with Ryan's firm for at least 10 years, maybe 15. It goes back a long time. It's taken him that long to grow the beard. Anyhow, that would take me that long to grow a beard. So thank you everybody for joining us. Let me just take a moment. Obviously, you know, I want everybody to raise their right hand, swear on the Bible, that they've read the legal disclaimer, that they understand that I am not your lawyer, although some of you I be or our firm might be. But no matter what the circumstance, everything that we are saying on this webinar is informational only. We advise you that if you hear something that you think is actionable, that you contact your attorney and you get sound legal advice before you run off and rely upon that advice to your detriment or perhaps to your benefit. So what will we be discussing today? We are going to kind of bounce back and forth between Ryan and I. His focus is obviously going to be the area that his firm specializes in, which is conducting traffic studies and data analysis. His firm fills a gap, a void, a need for any company that is providing a service like interconnected voice over IP or wireless, where companies sell services as bundles. And the FCC rules allow you to do a geographic allocation based on one of three methods that we'll get into. But before we get there, we've had the Universal Service Fund for about 25 years now. And when it first came into existence in '98, but actually started to take real effect with the Form 499 in 2000, the contribution factor was probably in the 4% to 5% range. In the ensuing 24, 25 years, as we'll get to later in the presentation, that contribution factor has gone up to, well, it's going to be almost 35% heading into the fourth quarter of 2023. So in just a couple of days, we're going to kick off the first time ever at a 34.4% contribution factor. And we're going to get into some of the reasons why that's happening, why that factor is gone up as high as it's gone, why it is likely to go even higher if there isn't reform. And we're going to get into some of what those reform measures might look like, because things are really starting to take shape at the courts, in Congress. The ball is finally starting to move downhill and pick up some steam. And I'll get a little bit into some reading of the tea leaves and forecasting what we might be looking at over the next couple of years. We're also going to get into the area of optimizing your revenue reporting, because with a contribution factor as large as 35%, you can't hide that. It is impacting how your company's services are priced to end users. Because if you do nothing to optimize your product catalog and your revenue reporting built off of that optimized product catalog, if you're not taking advantage of all of the lawful means by which you can reduce the exposure of revenue to the Universal Service Fund and other regulatory program fees, You're subsidizing your competitor. You're making your products non-competitive. You have to comply, but you don't have to comply blindly, and you don't have to comply stupidly, right? So that's why I have on the side, to save lots of dollar signs, you have to spend a little money. So invest in your success. That's going to be one of the themes of the webinar, is spend some money to save yourself and your customers a lot of money. And it's not just saving a cost, right? Because ultimately, most of the companies in the industry pass through the universal service fee as a surcharge to their customers. But you are actually saving your company money because you are reducing churn. Because if you're passing through 30% on $100 of revenue, and your competitor is passing through 7, 8, 9, 10%, again, there's a massive price differential if you're not optimizing. We're going to get into some of the alternative revenue allocation methodologies, not just the geographic allocation methodologies that are available under the bundling rules, but also the telecom, non-telecom unbundling that also is available under the FCC rules. Also going to get into just what are the top 3 reasons why your company might want to consider investing in, and I'll use this phrase throughout the webinar, independent third-party traffic study. And all of those words are important. And we're going to get into all of that later on. The key one is you want to stay compliant and competitive, and a traffic study is one way to help you do that. Traffic studies have a very long track record of being successful, and I'll get into details of our own experiences over the course of the past 15 years, just to demonstrate that using an independent third party to perform a traffic study does have a very high success rate. And then another one that's been a bit more of a recent development, as privacy laws start to take effect in other states like California and Colorado, and they're really starting to take off in many states. Companies have very strict privacy policies. They don't want to hang on to their records for very long, and yet the FCC has a 5-year record retention policy. So there's a interplay there that we'll get into. So jumping over the next slide, where are we with the Universal Service Fund system? Obviously, at 35%, it's I say on the verge of collapse, because it is getting to the point of unsustainable. The amount of revenue that is going into the program to support the $8.5, $9 billion a year that has to go out in distributions to the multiple different areas of the distribution side, schools and libraries, funding some broadband nowadays, still funding Lifeline, and also the high cost program. So, the money is being reduced because consumers are demanding different service offerings, traditional telecommunications offerings like long distance that used to be a major contributor is no longer. Who does long distance nowadays, or who's done it for 10 years? The companies that are contributing to the program are interconnected voice over IP providers, wireless providers. Again, but even wireless providers benefit greatly from the unbundling. And trust me, wireless companies unbundle and they optimize. So T-Mobile, AT&T Wireless, Verizon Wireless, they are all optimizing. They are all taking advantage of the FCC rules to minimize their contribution obligations. All of those things are conspiring to lower the amount of money that goes into the program, and ultimately, with outflows remaining at $8 billion or $9 billion, you have to fund it, and the only way to do it is that contribution factor keeps going up and up and up. But reform is on the horizon. I know I've probably been saying this for a decade, but it feels real this time, right? Like before it was the FCC, now it's Congress. Now there's there are things happening in the courts. But it's not going to happen overnight. My prediction is that just natural process of what it's going to take Congress to act, given the political makeup of Congress and the government, being an election year, what's happening at the courts. I'll get into that later, but a lot of things are conspiring. I'm not saying that this is going to happen in 2023 or even 2024. My best guess is that 2 to 3 years, we're going to see some real reforms happening, possibly adding broadband revenue to the contribution base, possibly adding this concept of, big tech, the FANG companies, the big heavy users of broadband services, and the ones that are burdening the broadband system and the Universal Service Fund now. So again, we'll talk about all those aspects of potential reforms, but they are years away. And in this industry, 2 or 3 years is a lifetime. And you have an opportunity over the course of the next few months to tee up your company for that next 2 to 3 years, or potentially longer if things don't turn around, to benefit your company, to benefit your customers, to lower costs, and make yourself more competitive. So again, I've already gotten into this a little bit in terms of what factors are conspiring to jack up the contribution factor as high as it's gone. But we've seen in the past couple of years some studies, digging into the underbelly of the Universal Service Fund program, and a couple of them have been sponsored or funded by or backed by firms like Encompass, which is a trade association representing a number of broadband providers, Public Knowledge, which is a public interest group, and the hundreds of stakeholders that I referenced. These are broadband companies that are saying, we should probably consider adding broadband revenue to the contribution base, because if we did so, the addition of just broadband is predicted to bring the rate down, the contribution factor down to 4 or 5%. And I will provide the link to the presentation afterwards to anybody who's attending or who registered. You can click the links and get the US Forward report. You can get the more recent Brattle Group report study that Encompass sponsored. They're both excellent resources just to get your arms around and understand the genesis of the problem that we're all confronting. And you'll see that this is not sheer speculation, that there are real legitimate reasons why if reform does not happen, the contribution factor could rise to as high as 50% or even higher in just the next 3 years. So we are at a mission critical point in time. And again, that's why I think we're starting to see some forces in Congress and the courts come together to really give us some hope that there is going to be reform on the horizon. So going through each one of these, right? You've got imminent reform, but imminent is it's happening, but it's not going to hit for a couple of years or longer. You've got, is someone managing the calls? We'll let them in. So, great. So first, last summer, we in the communications bar had some hopes that, well, the industry as well, that the FCC would listen to the lobbying that they were presented with. They were given with a great opportunity by Congress in the Infrastructure Reform Act to present their findings and actually take action, potentially take action. As I get into in another slide, the FCC just punted that opportunity. So the executive branch, they had their chance. The FCC is kind of back down. Well, what's happened in that interim period, of course, is that other branches of the government have gotten involved. notably the judicial branch. So there are multiple appeals being filed that are really challenging the core foundation, the underpinnings of the entire program. The USAC itself is being challenged under the non-delegation doctrine. Those appeals have largely been unsuccessful, but there's one that looks like it might give rise to a circuit split, which would potentially create this opportunity for the Supreme Court to take up an appeal. And really the one that has me the most optimistic is the legislative branch Congress, the U.S. Senate USF working group. So again, getting back to what happened with the FCC, right? So, peak COVID era, Congress went and authorized $1.2 trillion of federal spending. Let's ignore the fact that our mortgage rates, interest rates are going through the roof because of all the spending. Let's focus on the issue at hand, which is in that act, Congress told the FCC, we want you within a year of passage of the Infrastructure Investment and Jobs Act to provide us with a report that tells us what do we need to do, what's wrong with the Universal Service Fund program, what can we do to fix it, how do we maximize the distribution of the $40 billion of taxpayer dollars that were earmarked to fund universal broadband. It was given, a golden opportunity, as I say, to do something. And there was a lot of lobbying, Encompass and AT&T. The industry got behind either, pro reform the fund, just doing it through Section 254 of the Act, which the FCC has authority to kind of manage the Universal Service Program through 254, to add broadband revenue, basically declaring broadband revenue subject to the Universal Service Fund only, sort of very limited, narrow regulation of broadband for the purpose of investment in the Universal Service Program. That did not take hold. It was just too politically difficult, I think, for the FCC to justify taking action. It ended up punting. It sent its report to Congress last August, just over a year ago, and it basically said that we're here, we're happy to work with Congress and other federal agencies, but we're not going to do it. So, FCC, executive branch, somewhat out of the picture. Courts. So in that period of time, there have been a number of legal challenges to the Universal Service Fund quarterly contribution factor by Consumers Research, Cause-Based Commerce, and some individual customers that were named appellants. They filed in multiple courts of appeal across the country. They filed in the 5th, the 11th, the 8th. I think they also filed in the DC Circuit, if I'm not mistaken. If you look at what is happening, this is a group that largely speculated to be backed, either directly or indirectly, by some powerful forces who do not want broadband to be added to the contribution base. Businesses that don't want, Congress or the FCC, making their customers pay more, have pushed back, and they've sort of taken a court approach. They've taken a judicial appeals approach. They are seeking to get a circuit split in the courts to eventually get the Supreme Court to grant a writ of certiorari to take a case. They are challenging the constitutionality of the program's administration and the entire underpinning of the programming under what's called the non-delegation doctrine. And I know, although we have a number of lawyers as participants, we don't need to bore the audience with all the details about constitutionality and unconstitutionality. Suffice to say that there's sufficient grounds for them to file their challenges, and there may be sufficient appeal within conservative courts to limit the executive branch agencies, the bureaucratic state, from doing more than what Congress specifically authorizes them to do. So my expectation, again, I'm no soothsayer, but if they succeed in getting one of the circuit courts to agree with their arguments that the FCC violated the non-delegation doctrine in the creation of USEC and the administration of the Universal Service Fund program, we could certainly see the Supreme Court taking up the case. Now, when's that going to happen? It would not happen. Well, first, you have to get the circuit split. The latest update there is that although a 3-judge panel in the 8th Circuit did deny, the full circuit court did agree to review that panel decision. And the reports back from the oral arguments is that some of the judges were really seemed very, very convinced of the appellant's arguments. And so again, that's some tea leaf reading that the 8th Circuit might be the one that gives us that circuit split that would then open the door to an appeal to the Supreme Court when Supreme Court would take it. And with what's the majority now, 6-3 conservative justices, very hard to imagine that if it gets to the Supreme Court, that the Supreme Court would not find it within its power to basically throw the baby out with the bathwater and say, start over. All right, so now executive branch out, judiciary branch kind of moving through the process, seeing what was happening, getting the report from the FCC. About 6 months ago, the Senate, a bipartisan group of senators, created this USF workshop or working group. And in August, they solicited comments from industry stakeholders. And in those comments, a really interesting development. AT&T, which just a few years earlier had taken a policy position publicly that they wanted universal service reform to basically happen at Congress and be funded through the general fund. So our taxpayer dollars, would be spent to support universal service. That was sort of the AT&T policy of about 3 or 4 years ago. They recently, after this working group was formed and they solicited comments, a more recent policy statement, and again, you can click the policy statement when you get the presentation afterwards. Massive shift, really kind of signaling that AT&T would be open to adding broadband to the contribution base if, conditioned on big tech, the FANG companies, heavy users of broadband. So as long as Congress gives AT&T that ask, AT&T is signaling to Congress that they will give what is also necessary to drive this contribution factor down. And back up to some of those reports, the Brado group study and USF4, if you were to add just broadband, I said, you could get it down to 4 to 5% contribution factor overnight. If you then add this concept of big tech and some charge or some revenue-based system or some fees that are paid by big tech, you could see universal service fee contribution factor getting down to the 1.5%, 2.5% range, to the point where it's negligible, to the point where a lot of you guys aren't even hiring lawyers like me anymore, which I advocate for reform, but maybe I should back off a little bit and not be such a vocal advocate of working myself out of a job. But anyhow, we are here where we are. The system is here. It's going to stay with us for a while. I don't want to belabor the point, but 2 to 3 years is my prediction, right? So what are you going to do in the meantime? You're operating every month. You're sending out your customer invoices. Every month, every day of the week, you're competing for new business. Are you losing business because your pass-through is way too high when your competitors are charging 7, 8, 9% total tax load, but you're hitting your customers with 25%, 30% tax load? You can't wait. You shouldn't wait. Let's make the best of a bad situation. So let's go into some of the FCC rules that allow us to do some beneficial things. I'll kind of pick up the cadence here to run through some of these things a little bit more rapidly. The FCC's 499 revenue reporting rules allow a couple of different ways to optimize your revenue reporting in lawful ways. They permit 499 filers to unbundle bundles in order to isolate revenue that is accessible, meaning it's subject to the universal service fees based on the nature of the service and whether it fits certain regulatory definitions. And you can do that in your books. You don't have to show your homework, meaning you don't have to break it out on your invoices. There may be other benefits when it comes to state and local taxes. It's a whole other ball of wax that would benefit from breaking things out and showing your homework, showing your customers every single breakout component of a bundle. That's a whole other story. We can talk about that if you want to engage our firm. Not something I'm willing to get into on this webinar. So the other one, and this is where Ryan's going to jump in pretty soon, is the geographic allocation. Everybody knows about safe harbors, the 64.9% for the voice over IP safe harbor and the 37.1% for wireless. And those are really bad options, to be quite honest, for most companies, the vast majority of companies. Most companies are using some alternative method of allocating the geographic between interstate and intrastate, with, again, interstate portion of bundled revenue is subject to USF. Intrastate is not. There are a couple of other methods. Books and records, very generic term, but it just basically means whatever you have to support it. If USAC finds it reasonable, you know, they could accept it. But there's a high bar to determining what USAC will say is reasonable. Traffic studies, much more definite, much more certain, much less assailable. So let's jump into the safe harbor, right? So I just mentioned the two big ones, 64.9% for VoIP, 37.1% for wireless. Again, if you're not using one of the other alternative methods of books and records or traffic study methodology, you can use the safe harbor. We know from our experience in our practice that there are still, to this day, way too many companies relying on safe harbor. A lot of companies, oftentimes the ones that are reselling platform provider services, where the platform provider has not undertaken its, by itself, to the benefit of its customers, invested in a traffic study so that they can lower what their resellers have to pass through. We've seen a lot of that in our practice, where a platform provider could really benefit all of the customers it is selling to downstream white label resellers and so forth, if they underwent a traffic study to get a much lower PIU. So Ryan, I think we talked about this being a jump over, so I'll hand over the reins to you, and you can take it away.
Yeah, thanks, Jonathan. So I agree with you, of course, that some reform is necessary, but also agree with you that some of that reform. Do you hear an echo, or is that just on my end?
A little bit choppy, but keep going.
It might be echoing back to yours. There we go. Okay. So I agree with you that some reform is definitely necessary, but also that it might put us out of work a little bit. So kind of double-edged sword there. So we've been doing traffic studies with Jonathan and with many other companies since 2006, when the traffic study methodology became available for everybody. And we always say, knock on wood, in the probably 100+ traffic studies we've done since then, we've never found a single company to be at, above, or even really near safe harbor when it comes to voice over IP or wireless. And back in 2006, when they set those safe harbor rates, 64.9%, they even kind of admitted that it might be a little bit egregious, but they said voice over IP at this time is mostly used for interstate, international, but of course, over the last, 17 years, it's become what most people use in their houses. So it's not just used for interstate and international, but of course, they haven't adjusted those rates since then. And even the FCC admits that PIU is more likely near 35%. And in our experience, when doing the traffic studies, we'd agree with that. Most voice over IP traffic studies we do are roughly half of safe harbor, and we usually find around 32%. And it varies from there. We've seen some as low as 11, 12%, and some up in the 40s. But as I said, never anywhere near safe harbor when it comes to voice over IP or wireless. Just to kind of give you a rough example here, what Jonathan was talking about as far as your accessible revenue and what it really means to what you're passing through. And some folks aren't passing through. We've talked to a number of carriers that are not passing that through. And then it's a really big difference maker, and your bills are going to be significantly higher, especially as the PI or the as the contribution factor goes up. So this example is for a carrier with about $1 million in assessable revenue. And we use the contribution factor here from the third quarter, 29.2%. So you can see here the difference between the two. If you're using Safe Harbor, 64.9%, your contribution is around 189,000 spread across your customers. If you do the traffic study, and we find it to be about half, you're cutting that contribution about half, so about 96,000. And again, that's using the previous quarter's PIU of 29%. Going up to this quarter, it's about 5% higher. So it's going to increase and pass that through to your customers. Books and records versus traffic studies. So there's kind of a fine line here. And again, when USAC released the instructions on how to do a traffic study, or the ability to do a traffic study in 2006, there are a handful of guidelines you had to meet for the statistical analysis. Had to be 95% plus or minus, things like that. The amount of data that you had to use. They left a little bit of that up to either the carrier or the third party who was going to do that traffic study for them. And they really haven't released any official guidance since then. So they do their quarterly webinars, and if you jump on those, they do kind of speak through or mention some suggestions or new recommendations they have as far as how much data they use. But there's really nothing on record to say you have to use 3 months or you have to use 6 months or a year. There's nothing on record that says you have to do it every 1 year, 2 years, 3 years. So just on those webinars, they say things like, well, 3 months is a minimum, but we really prefer a year. They'll say things like, yeah, you can use it for more than 1 year, but we really recommend you use it. You redo your traffic study every year, because if you do a traffic study now and then in 2025 you're still using that same traffic study, we're going to take a look at that, because most likely your traffic patterns have changed over those years. So there's just some of those things that they kind of speak to, but haven't really officially changed since that initial recommendation or policy back in 2006. As far as books and records versus traffic studies, again, back to 2006, the ability to do a traffic study and process every single one of your call detail records. Technology at the time, 17 years ago, certainly wasn't at where it is now, where the ability to crunch through potentially millions and tens or hundreds of millions of records for a data set to figure out what your actual percent of interstate or international use was pretty cumbersome for a lot of companies, right? They weren't able to do it. So that's really why they said, okay, if you can't process all of your records, at least do a valid statistical analysis to show, I did X percentage of my records, and here's how I did it, and it met these thresholds and all that kind of thing. So the way we typically do our studies, because obviously now times have changed, for the past probably almost 15 years, we've been processing really both ways. So we run through every single record, and then we also do a statistical analysis, and we provide both in our report to show that if we process every single record, we see this, and if we had done the statistical analysis, we see typically the exact same numbers. So the way we do our analysis is a little unique. We kind of do both the books and records, which is doing 100% of your records, and the traffic study doing the statistical analysis. We really provide both in the same report, which really makes it a solid report for you to attach with your 499 filing. And again, knock on wood, in all those filings we've done. I'm echoing with you again, Jonathan. In all those traffic studies we've done over the past 17 years, we've never had a single one questioned or audited or anything like that. So we have a great track record when it comes to performing those traffic studies. And something Jonathan's mentioned a couple of times is the importance, or the importance of having an independent third party doing a traffic study. It's treated a little more favorably than doing your own, just because, obviously if you do your own, they might be a little more skeptical about if you did it the correct way, or if you kind of cooked it, or that kind of thing. So by doing it with independent third party, just makes it a little cleaner and makes it look a little more official, a little more unassailable as far as doing the traffic study that way. Jonathan, you want to jump in? Ben?
I'll raise my hand just to avoid the echo. Yeah, I wanted to echo Ryan's point there, which is, if you get an independent third party like an ATS to provide you with a traffic study, and we've had a number of instances where USAC will send out a notice of issue once a quarterly filing is made or an A has been filed. and they ask the question that I think many of you have probably seen: how are you, how are you allocating your revenue in line 414.4? We produce the traffic study report on the ATS paper, and we have not had a single instance where a issue notice got anywhere beyond asking the question and supplying the report. So just practical experience, actual experience, but certainly not a guarantee. There are no guarantees in life and law or anything. But knock on wood, very, very long track record of success.
Thanks. Yeah, so we've worked with a number of Jonathan's clients and a number of others, and I haven't kept track, but it's well over 100, probably getting close to 200 traffic studies that we've submitted, and they follow the right format and all that. So they've all been accepted well. Now, as far as the time period to use, I touched on that before. Back when we started doing these, we always started with a 3-month time period, 1 quarter, and that's still sufficient. But again, we typically recommend a year of data to look at, and USAC in those webinars has just verbally said we prefer a year, but we've submitted plenty with 3 months, and they get accepted just as well as the 1 year. So we always recommend a year just to be safe, but 3 months is typically acceptable as well. As far as how long to use that traffic study with your filings, we recommend you redo your study once a year. You don't have to do it quarterly and resubmit the traffic study quarterly. We recommend taking 1 year's worth of data, and then you can use that traffic study for up to a year. We do have some clients who will use it for a second year, and we've had some that will use it longer against our recommendations. But as USAC says, once you kind of get beyond that, you're really in the danger zone then of them looking at it and saying, this is from 3-4 years ago. This probably isn't a good representation of what your traffic looks like today. It might take a little closer look at it for you. So just again, when we do that traffic analysis, this is a little example of one of the statistical analysis we provide, just kind of breaking out by day of week and time of day and things like that. But one of the ways to do it is by looking at all the call detail records in order to lower the PIU. And we touched on some of this already, so I won't go through it again. But the statistical analysis has to meet the FCC's rules with that confidence threshold. And we do that books and records and statistical analysis to really just provide a solid case of whichever we picked. Here's what the PIU is, and here's the actual PIU. It's not safe harbor or really anywhere near that. And again, just to reiterate the options, right? There's lots of carriers who will do their own in-house and have some analysts in-house who are able to do that. And that's good and well, and they may be accepted just fine. I'm sure Jonathan has plenty of clients who do that and are fine. But I also know that he's brought some to us who were doing it internally and got that notice and said, questioning how they were doing the analysis, and then he's brought that to us and we do the study. So again, we've reiterated that point a few times, but using an outside vendor, independent third party, just gives some more validity to the traffic study when you go to do that finally. John, I'll kick it back over to you here.
Yep, I'll jump in. You can mute it so we don't have the echoing. Ryan and ATS, they are the traffic study experts. We've used them or recommended that our clients use them almost exclusively over the course of the past 15 years. There really aren't a lot of other independent third-party vendors that do this. Obviously, if you are working with a big firm like a KPMG or an EY or a firm that has the tools to do the study and also can do the sampling in accordance with the FCC's rules, there are other providers. But for many of our clients, ATS has really been the first choice. And there are a lot of reasons to shift to using a independent third-party traffic study. If you're doing it either safe harbor, there's the obvious reason. If you're doing books and records, you're doing it in-house, you're doing your own internal CDR analysis. Again, there are elements to what an ATS does that provides that imprimatur of professionalism, independence, and by being in an independent third-party report, it becomes less assailable, meaning USAC has less power, interest, and resource bandwidth to dig in, to peel apart the layers of the onion, to kind of dissect a traffic study. Whereas if a client is just submitting some internal spreadsheet with some number at the bottom that says, well, this is this much PIU, percentage of interstate traffic, and this is what's left for interstate, you give something like that to USAC, and there's a high probability they're going to go through it with a fine-tooth comb. So it's just one of those areas where we recommend to clients, if you want to invest in your success and keeping, those costs down, the potential cost of having to go into that endless cycle of back and forth with USAC during the issue notice process, with the uncertainty that exists around whether or not they're going to declare your PIU study or whatever you're using, your books and records, to be invalid and force you to use something like Safe Harbor in the alternative, it's certainly a better option in that regard. Harkening back to the optimization, doing the traffic study helps you to be competitive and yet be compliant. It has a long track record of success. And the newest one that really has started to percolate over the past few years is the document retention policy and the intersection with privacy laws. And I'll get into that in just a second. So we have gone over the optimization previously. This is a great slide for anybody who is going to get this presentation after the event. Just click through it. We've got a great site that details how we go through a 5-step process to help our clients achieve, optimized and reliable telecom and tax and regulatory fee compliance. It's a worthwhile read. Even if you don't retain our firm or work with our firm, I think you'll gain a hell of a lot of insight into, all of the things that you could be doing in order to improve your situation, to avoid a situation where your failure to do everything you can under the law to optimize your product catalog and your revenue reporting ends up making you non-competitive and ends up subsidizing your competitors. So again, I think we've belabored this point, and I want to leave a little time. We've got some questions, so I'll jump ahead to the next one. Again, traffic study is just one of the primary 2 ways you can optimize. The other one is the FCC has bundling rules, and it's not just limited to voice over IP and wireless. There are other, the bundling rules are more generally applicable. So anything that you sell as a bundle, that maybe you're bundling in some information services, some internet access, something that's non-telecom. Maybe you're bundling in professional services and support, or you're bundling in the maintenance of the equipment that you're selling to the customer and putting on the customer prem. A lot of different things might go into your bundled offerings that you can, on the books, not necessarily breaking it out on your invoices, separate and only allocate the portion of the revenue that is actually fitting the definition of what is a regulated and accessible service for purposes of the Universal Service Fund. So again, go in and check out the brochure, check out the website, a lot more details on the unbundling options and how you can optimize. And the last thing to mention when it comes to optimizing is, if you're going to spend costs on Ryan and ATS for a traffic study, if you're going to spend money on Jonathan and CommLaw Group, or the consulting firm Compliance Group, or whoever you are paying to help you do your compliance, if you have other costs that you're not able to potentially recoup, and you want an industry standard way of recouping these expenses, work with your counsel to design a defensible, lawful cost recovery fee, because you can recoup the cost of compliance as long as you're doing 3 key things to being successful. Make sure it's reasonable. Make sure you're clearly disclosing to your customer what it is and what it's comprised of, and then your books and records, your accounting books, they need to back up what that revenue is going to look like, because it is revenue. You're deriving revenue that's offsetting costs, but those costs have to be assigned, allocated, and make sure they're visible, and don't have a 5% profit margin on top of your cost recovery fee. That's yeah, don't do that. Why else do you want to go to the third-party independent traffic study? It's reliable. They've been successful. They're easier to defend. But again, Ryan referenced this when he was discussing the timeliness. As a lawyer, again, you're not taking legal advice from me, but as a lawyer, if I were doing this, I wouldn't use a 2021 traffic study to report revenue in 2024. Okay, that is in and of itself a red flag. Okay, and you could certainly it just creates a situation where you don't want to trigger that issue notice at USAC if you're not prepared to answer in 7 days. And your answer really, if it's going to be, well, here's our traffic study. Yeah, it's 3 years old. You're gonna wish you had a traffic study done in 2023 or at best 2022, right? As Ryan said, the rules are not crystal clear. There is some room for interpretation, but you don't want to leave too much into the hands of USAC and their interpreters, because the tendency would be, especially in this environment where the contribution factor is skyrocketing, there's going to be a tendency to find missing revenue under the couch cushion. So, and lastly, I think this is going to be a new one for a lot of people on the call. The FCC document retention period for anybody that is reporting revenue in their Form 499 is 5 years. So if you're relying on your books and records to allocate revenue from your voice over IP or wireless services into that percentage of interstate use, you're using CDR records. You have to keep those CDR records for 5 years to back up your reporting. Well, with the CCPA in California and in Colorado and other states, and just generally this heightened concern about consumer privacy, CDR records are the sine qua non of CPNI. That is customer proprietary network information. It is customer privacy data. It will fall into your company's privacy policy. And if your company has a privacy policy that is like, we've got clients that want to drive their privacy policy to basically retain, customer information, private information, for as little as 1 day or less. They don't want that in their systems, because the longer it's in their systems, the longer they're exposed, the longer period of time they can be subject to a hack and exfiltration and a breach and so forth. So privacy policies are kind of driving down this time period that you can retain those books and records used to support your revenue reporting. If you have an independent third-party traffic study performed, that is your books and records. That is the documentation that you are using to support your reporting. It is a minimal investment to avoid the exception to your privacy policies, and also get a lot of data off of out of storage and not having to pay storage costs. Not that they cost a whole lot these days, but just another factor to consider. So with that, we'll conclude with about 10 minutes left. Let's see, I don't know how we want to exactly handle the questions that may have come in. John, are you tracking where those are, and would you possibly be able to throw a couple our way?
Yeah, I see a couple here.
Yeah. Ryan, you want to take it away?
Sure. Sorry, John. I'm just going to mute you so I don't get echo. But someone asked if there's a threshold, either dollar-wise or minute-wise, for doing or omitting traffic report filing every year. There's not a threshold for omitting doing the filing. There is what's known as de minimis, where if you still have to do your filing, but if your revenue that you would have to pay into universal service is under a certain amount, I believe it's somewhere around 11,000 or 12,000, I forget the exact amount, then you don't have to do any contributions. You get to just keep that revenue. And that's a point that I was going to touch on as well, is that there's a lot of companies that are kind of right up on the cusp of de minimis. And assuming you're doing your filings and you're properly registered and all that, but you're right around de minimis or maybe slightly over and using safe harbor, I can almost guarantee you by doing a traffic study, you will remain under de minimis and be able to keep all that revenue and not have to provide any of it to USAC. So that's a really important thing. If you're right on that cusp, highly, highly recommend a traffic study to reduce that PIU and stay under the de minimis amount, but still making sure that you're compliant in registering and doing your filings.
So Ryan, I'll jump in. You can mute. I'll take the next question. Andrew Elliston asked, can you go over the option of bundling or what's recommended? Should we or should we not bundle? Obviously, that's a question that kind of begs me to provide you with information that you might rely upon. So with the cautionary note that this is just an informational example, don't run off and rely on what I'm saying. But it's multifaceted, right? So as with everything law related, the facts matter, your particular circumstances matter, your risk tolerances matter, how geographically dispersed or spread out your business happens to be across the country. A lot of different factors go into the question, how do we present our products and services to our customers? So I'll just recite to you what the FCC rules are. FCC rules allow you to unbundle on the books. That means you can sell a $20 seat on your network, on your voice over IP network. And within that $20 seat, well, maybe part of that is recouping the cost of, leasing phones or maintenance on the equipment that goes along with the VoIP service you're selling. Maybe part of that is the PBX platform, the soft switch, the software, the enhanced features, the enhanced software features, the ones that would not necessarily be thought of as part of the telecom revenue, the voice over IP revenue. Professional services, lots of different things might go into that $20, right? So if your objective is minimize your regulatory fees and you don't really care about state and local taxes, and you're okay with the full $20 being taxed at the tax rates and the volume of taxes that apply at the state and local level of communication services, then unbundling on the books is certainly an option that is simpler, easier to invoice, et cetera, et cetera. If you're on the other end of the spectrum and you're selling services in all 50 states or a whole bunch of states, and you have communications tax exposure, and the communications taxes tend to be the most onerous. It's, a lot of states have a sales tax on communication services as well as local taxes on communication services. California is a great example, right? California has no sales tax on communication services, but they have UUTs, utility users taxes. If you're not showing your customer the different components of the bundle, you're going to have a hard time defending to a tax auditor that the full $20 shouldn't be taxed at the highest rate, which is, the telecom communications taxes. And I shouldn't just say highest rate, because a lot of the rates are the same. It's just you got 50 states and their sales taxes. A lot of them have locals. Telecom taxes are literally thousands of telecom taxes all across the country because they're at the local level. They're all over the states. They've got a bunch of wacky, weird taxes that apply to telecom services that don't apply to anything else. So, yeah, that's one where before you make a decision, you run off and do something. I would highly, highly, highly recommend soliciting counsel and doing it the right way and getting good advice and understanding the pros and the cons and the risks and the rewards. So hopefully that responds to that question sufficiently. Let's see if there's another one. Does using a traffic study increase the risk of an audit? Well, in our experience, and I can only speak from our experience, I would say it reduces the risk of an audit. It not only reduces the risk of an audit, but it makes responding to the quote unquote mini audits, the issue notice experience, a quicker, simpler, usually a lot easier to move on, at least from that particular question, that particular issue of how are you justifying your splits? How are you justifying your interstate versus intrastate allocations? So someone asked if I'm taking on new clients. Of course I am. We wouldn't be doing this if we weren't. I'll speak for Ryan as well. I'm sure he's willing to take on some new clients. Lawyers have to say, as long as there are no conflicts, I don't think Ryan would have much of a conflict with anybody, as long as you can provide good data, he can provide good results. Do we have any other questions from the audience? Here's one more. What is the risk of an audit? Oh, if you change from safe harbor, that's a great question. Any change, any material change from one period to another, quarter to quarter, but more likely annual to annual, from a 2022 499A to the 2023 499A, any material change is going to be almost an automatic red flag. It's almost automatically and guaranteed to give rise to a notice of issue. I don't know how USAC does it, but I can assure you that they've built in some materiality thresholds, potentially as low as 5 or 10%. If they see something changing, or if the system sees something changing, it's going to get flagged, it's going to be assigned, and someone's going to be reaching out to you asking questions about it. The best thing that you can do if you are doing something that results in a material change is do it consciously. Know that you're making the change and be prepared to defend it. And if you're changing from safe harbor to a third-party independent traffic study, I would tell you your concern level should be pretty damn low about that spiraling out of control and into something more problematic than just a, hey, how did your, why did the numbers change dramatically from year to year? As long as everything else is aligned and you haven't over collected your USF pass through, and other things check off the boxes and things look good, a material change where the change can be defended with a third-party audit, it's not a high risk, high concern area. But again, there are a lot of different collateral issues that come into play. So anybody who does make a material change would certainly want to have counsel or good consultation before they make those changes. And also be aware, when you make the change in reporting, try to make those changes before a annual reporting period. I think in one of the slides that I forgot to mention was, now's a really good time to be evaluating whether you should make some changes to how you report revenue. Because wouldn't it be great to start your January 1st invoice cycle shaving off 25, 35, 40% from what your customers are having to pay in pass-through surcharges? You'd want to get the process started pretty quickly if you want to get things in place, because November 1st, 499Q, that's when you're projecting revenue into the first quarter of 2024.
Right.
So with that, I don't see any other questions. Ryan, do you have any closing remarks? Otherwise, I'll let you or John just close out.
Yeah. No, the only other thing I was going to say was kind of reiterate what you just said, is that A filing at the time, and even USAC, and again in their webinars, they've indicated if you're going to make a change, if you're going to switch from safe harbor to a traffic study, that November filing is the time to do it for your next year, so you kind of start fresh with your new taxes for the following year. So, but thank you very much. I think that was great. I think that's very informative, and hope everyone got a lot out of it. I stuck you on mute. You're gonna have to unmute yourself. Sorry, Jonathan.
I'm muted. As I said at the beginning, let me find it. Everybody is graduating from Regulatory Compliance 101. So thanks, everybody. We appreciate it. And Ryan and I will obviously be standing by. If anybody has questions, feel free to contact us offline. Thank you.